whenever you're ready.
Please be seated.
Your Honor, can we approach 310 final issue?
Granted.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview.
All right, and ladies and gentlemen, thank you for your patience this morning. I said we'd hopefully be quick, but we had some administrative chores to do, and it took a lot longer, and then we had some technical issues as well. So, and before we get started, state and the defense acknowledge the presence of the jury.
The state does.
Yes. Yes, Your Honor.
And because of the challenges we had getting the instructions done, I believe, have you distributed the instructions, Bailey?
Yes.
Each of you should have a printed copy of the instructions with you. I'd ask that you pay attention to me reading them to you instead of reading them yourselves, but you can follow along. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. ANCEL KIMANI Sterling, the defendant in this case, has been accused of the crimes of traveling to meet a minor facilitated by a parent, legal guardian, or custodian, and unlawful use of a two-way communication device. Traveling to meet a minor facilitated by a parent, legal guardian, or custodian. To prove the crime of traveling to meet a minor facilitated by a parent, legal guardian, or custodian, the state must prove the following two elements beyond and to the exclusion of reasonable doubt. 1, Mr. Sterling used a device capable of electronic data storage and transmission to solicit, lure, entice, or attempt to solicit, lure, entice a person believed by the defendant to be the parent, legal guardian, or custodian of a child to consent for the person believed by the defendant to be a child to participate in unlawful sexual conduct in violation of Chapter 794, 800, or 827 of the Florida statutes. Mr. Sterling then traveled within this state for the purpose of engaging in any illegal act described in 794, 800, or 827 with a child or a person believed by the defendant to be a child. The mere fact that an undercover operative or law enforcement officer was involved in the detection and investigation of this offense shall not constitute a defense from prosecution. If the evidence does not convince you that the defendant committed the main crime of which he is accused, there may be sufficient evidence that he committed a lesser included crime. In other words, if you decide the main accusation has not been proved beyond a reasonable doubt, you will need to decide if the state proved beyond a reasonable doubt that the defendant is guilty of a lesser included crime. The lesser included crime of traveling to meet a minor facilitated by a parent, legal guardian, or custodian is soliciting a parent, legal guardian, or custodian of a child for unlawful sexual conduct using computer services or devices. To prove the crime of soliciting a parent, legal guardian, custodian, or custodian of a child for unlawful sexual conduct using computer services or devices, the state must prove the following two elements beyond and to the exclusion of reasonable doubt. One, Mr. Sterling knowingly used a device capable of electronic data storage or transmission to contact a person the defendant believed to be a parent, legal guardian, or custodian of a child. Two, during that contact, Mr. Sterling solicited, lured, enticed, or attempted to solicit, lure, or entice a person believed by the defendant to be a parent, legal guardian, or custodian of a child to consent to the participation of the child in any illegal act under 794, 800, 827, or any unlawful sexual conduct. The mere fact that an undercover operative or a law enforcement officer was involved in the detection and investigation offense shall not constitute a defense from prosecution. The following definitions apply, excuse me, the following definitions apply to the crime of traveling to meet a minor facilitated by a parent, legal guardian, or custodian, and the lesser included crime of soliciting a parent, legal guardian, or custodian of a child for unlawful sexual conduct using a computer, services, or devices. A child means any person whose identity is known or unknown, younger than 18 years of age. Sexual conduct means actual or simulated sexual intercourse, deviant sexual intercourse, masturbation, actual or simulated lewd exhibition of the genitals, actual physical contact with a person's clothed or unclothed genitals, pubic area, buttocks, or if such person is a female, breast, with the intent to arouse or gratify the sexual desire of either party, or any act or conduct which constitutes sexual battery or simulates that sexual battery is being committed. Sexual battery means oral, anal, or female genital penetration by or union with the sexual organ of another, or the anal or female genital penetration of another by any other object. However, sexual battery does not include an act done for bona fide medical purposes. Bona fide means genuine. Union means contact. Deviant sexual intercourse means sexual conduct between persons not married to each other, consisting of contact between the penis and the anus, the mouth and the penis, or the mouth and the vulva. Unlawful use of a two-way communication device. To prove the crime of unlawful use of a two-way communication device, the state must prove the following two elements beyond and to the exclusion of reasonable doubt. One, Mr. Sterling used a two-way communication device. Two, he did so for the purpose of facilitating or furthering the commission of a felony. The court instructs you that traveling to meet a minor facilitated by a parent, legal guardian, or custodian is a felony. The term two-way communication device includes but is not limited to a portable two-way wireless device. If you'll recall, before we began the trial, I gave you a preliminary instruction on the law, and I told you that at the conclusion I would provide you a complete instruction, and if there were new or different instructions, I'd inform you. The instructions I've provided you now are substantially the same, with the inclusion of the lesser included offenses and the definitions that have been provided to you this time. The defendant has entered a plea of not guilty. This means you must believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything except for the defense of entrapment to the crimes charged in this case. The law does not require proof beyond all doubt on part of the jury before it returns a verdict of guilty. A mere possible, speculative, imaginary, or forced doubt is not a reasonable doubt. A reasonable doubt is not a guess or mere conjecture. Rather, it is a doubt based upon reasoning and common sense after careful and impartial consideration of all of the evidence in the case. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If after a careful and impartial consideration of all the evidence, you have a reasonable doubt as to the guilt of the accused, it is your duty, it is your obligation to find the defendant not guilty. On the other hand, if after a careful and impartial consideration of all of the evidence, you are convinced beyond a reasonable doubt that the defendant is guilty, it is your duty, it is your obligation to find the defendant guilty. It is to the evidence introduced in this trial and to it alone that you're to look for that proof. The defense of entrapment has been raised. Mr. Sterling was entrapped if, 1, he was, for the purpose of obtaining evidence of the commission of the crime, induced or encouraged to engage in conduct constituting the crimes with which he's been charged in this case, and 2, he engaged in such conduct as a direct result of such inducement or encouragement, and 3, the person who induced or encouraged him was a law enforcement officer or a person engaged in cooperating with or acting as an agent of a law enforcement officer, and 4, the person who induced or encouraged him employed methods of persuasion or inducement which created a substantial risk that the crime would be committed by a person other than one who was ready to commit it. And 5, Mr. Sterling was not a person who was ready to commit the crime. Entrapment is not a defense to a crime if Mr. Sterling had a predisposition to commit the crime. Mr. Sterling had a predisposition if before any law enforcement officer or person acting for the officer persuaded, induced, or lured Mr. Sterling, he had a readiness or willingness to commit the crimes charged in this case if the opportunity presented itself. It is also not entrapment merely because a law enforcement officer, in a good faith attempt to detect crime, A, provided the opportunity, means, and facilities to commit the offense which the defendant intended to commit and would have committed otherwise. B, used tricks, decoys, subterfuge to expose the defendant's criminal acts. On the issue of entrapment, the defendant must prove to you by the greater weight of the evidence that the law enforcement officer or agent induced or encouraged the crime charged. Greater weight of the evidence means that the evidence which is more persuasive and convincing. If the defendant does so, the state must prove beyond a reasonable doubt that the defendant was predisposed to commit the crimes charged in this case. The state must prove the defendant's predisposition to commit the crimes charged in this case existed prior to and independent of the inducement or encouragement. Inducement is defined as any government conduct creating a substantial risk and otherwise law-abiding citizen will commit an offense, including persuasion, fraudulent representation, threats, coercive tactics, harassment, promises of reward, or pleas based upon need, sympathy, or friendship. Neither mere solicitation nor the creation of opportunities to commit an offense constitutes inducement. If you find the defendant was entrapped, you should find the defendant not guilty of the crimes charged in the case. If, however, you find the defendant was not entrapped, you should find the defendant guilty if all of the elements of the charge have been proved. Weighing the evidence. It's up to you to decide what evidence is reliable. You should use your common sense in deciding what is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than the other evidence. You should consider how the witnesses acted as well as what they said. Some of the things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case was to be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony the witness gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or the number of exhibits it is offered, but instead it depends upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that the testimony deserves more or less consideration than that of any other witnesses. The defendant in this case has become a witness. You should apply the same rules to the consideration of his testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness will give if called to the courtroom. A witness should not be discredited by talking to a lawyer about his testimony. You may rely upon your own conclusions about the credibility of a witness. A juror may believe or disbelieve disbelieve all or any part of the evidence or testimony of any witness. A statement claimed to have been made by the defendant outside of court has been introduced into evidence. Such a statement should be considered with great caution and be weighed with great care to make sure that it was freely and voluntarily made. If you conclude that the defendant made the statement, you must also determine from the evidence whether the defendant's statement was freely and voluntarily made. In making this determination, you should consider the circumstances, including but not limited to: 1, whether when the defendant made the statement, he had been threatened to get him to make the statement, and 2, whether anyone had promised him anything to get him to make the statement. If you conclude that the defendant made the out-of-court statement, but it was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussions, and you must follow these in order to return a lawful verdict. 1, you must follow the law as it's set out in his instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of exhibits in evidence in these instructions. 3, the case must not be decided for or against anyone because you feel sorry for anyone or you're angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in any way. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence should the jury determine the defendant to be guilty. 7, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. In reaching your verdict, you must not consider the defendant's race, color, religious belief, or national origin, or sex. You are not to return a verdict for or against the defendant unless you would return the same verdict without regard to his race, color, religious beliefs, national origin, or sex. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. Scientists studying the way our brains work have shown that for all of us, our first responses are often like reflexes. Just like our knee reflexes, our mental responses are quick and automatic. And even though these quick responses may not be what we consciously think, they could influence how we judge people or how we evaluate the evidence. Scientists have taught us some ways to be more careful in our thinking that I ask you to use to consider the evidence in this case. Take the time you need to test what might be reflexive, unconscious responses and to reflect carefully and consciously about the evidence. Focus on individual facts. Don't jump to conclusions that may have been influenced by unintended stereotypes or associations. Try taking another perspective. Ask yourself if your opinion of the parties or the witness or the case would be different if the people participating looked different or if they belonged to a different group. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from you. Working together will help achieve a fair result. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. If during this trial I've done something, I've said something, or I've acted in some way that makes you believe I prefer one verdict over the other, I pray that you disregard that. I do not have any preference over one verdict or the other in this case. You may find the defendant guilty as charged or guilty of a lesser included crime as the evidence may justify. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree on the same verdict. Only one verdict may be returned as to each crime charged. A separate crime is charged in each count of the information, and although they've been tried together, each crime and the evidence that applies to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. The verdict must be in writing, and for your convenience, a necessary form of verdict has been prepared. Do you have one?
May I approach you?
Granted. Thank you, Ms. Leon. Now, I know it's difficult for you to see the specific details from all the way over there, but I like to sort of go through the format so you'll understand what I'm discussing with you. At the top of the page is the style of the caption, and this is really used by the clerk and the court to keep track, and it says, in the Circuit Court for Okaloosa County, Florida, State of Florida versus ANCEL, KIMANI, Sterling. It has the clerk's case number, which is 4624 CF 002653. At the top, it says verdict form. At the bottom, it starts with the statement, "So say we all." A place for the foreperson to sign, a place for the foreperson to print their name, and a place to date. Now, at the top, it begins, "We, the jury, find as follows," reinforcing the "so say we all" and the unanimity required in reaching your verdict. At the top, it says, "As to count one," and you'll see that there's a second section, "As to count two," reinforcing what I've told you, that there's a separate verdict for each count. As to count one of the information, and an instruction reminding you can only have one verdict as to each count. There are three places as to count one. The defendant is guilty of traveling to meet a minor, facilitated by a parent, legal guardian, custodian. The second place, a place to check, the defendant is guilty of the lesser included offense of soliciting a parent, legal guardian, or custodian of a child for unlawful sexual conduct using a computer, services, or devices. And then third, the defendant is not guilty. In the second section, as to count two of the information, check only one as to this count. And the first is the defendant is guilty of the unlawful use of a two-way communication device. And then the second is the defendant is not guilty. And we'll repeat, "So say we all," reinforcing the requirement that your verdict must be unanimous. Excuse me just a second. The lawyers will now have the opportunity to make their closing arguments. Please remember what the attorneys say is not evidence or instruction of law. However, do listen closely to their arguments. The arguments are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an initial closing argument and a rebuttal argument after the defense has spoken. Ms. Leone.
Yes, sir. Members of the defense, Your Honor. May I have the screen, please?
jury?
Yes. Good afternoon. Ladies and gentlemen, at the beginning of this trial yesterday, I told you that you would hear a recording. I told you that you would hear the defendant choose a 14-year-old girl over an adult. The defendant is charged with traveling to meet a minor, facilitated by parent, legal guardian, or custodian, and unlawful use of a two-way communication device. In the recording that came out during the testimony and the evidence section of this trial, you heard the defendant saying the young one, not once, but twice. You all heard it. We all heard it. I also told you that he would drive from Fort Walton Beach to Crestview at nearly midnight with cash in his pocket. The evidence again showed that he did, that he traveled. Himself told you that he did drive from Fort Walton Beach to Crestview. His own phone would tell you the story that he tried to hide. On that phone, you find the text messages, the phone call that he placed after he saw the post, the profile on Skip the Games, the calls, the photo that he took, used the phone to navigate from Fort Walton Beach to the Fairfield Inn in Crestview. You cannot unhear his voice. You cannot unexplain why he was in the parking lot of the Fairfield Inn in Crestview around midnight with the cash. And you cannot explain away the photo that he took with his own phone to reassure the person who was waiting for him at the hotel that he had arrived. Let's start from what you heard and what you've seen. You saw, this is the profile that Agent Horn explained to you, prepared for this ICAC operation, Internet Crimes Against Children operation, undercover operation. And that shows what the defendant, this screen recording will show you what a person who accessed that website would look at, clicking on the various links. And you will have this with you during deliberation if you wish to review it more carefully. The title of the profile was Miss Delaney. It's important to think, keep that in mind. That was the profile that Special Agent Horn had prepared for this. Then we have the phone call.
Hello? Hey man, that's how you called. Were you looking for Delaney?
Huh?
I just saw you called. Were you looking for Delaney?
Yeah.
Yes, I got two right now, man.
1 second. So, who's Delaney? Delaney is that, supposedly, of course, the girl represented in those photos at the end of the post, right? The profile. Now, I understand that the defendant said that he thought that girl represented in those photos looked in her mid-20s. I'll let you decide whether that's the case. However, the point is, he called for Delaney.
Yeah, so I got Delaney's free, and then I also got Jen, so I wasn't sure which one you were looking for.
I don't know. Which one's better?
Which one's what?
Which one's better?
Better? Well, it's just preference. Jen's a little bit thicker. She's older. She's 39. Delaney's 14, though, so it really just depends on what you're looking for.
Delaney's what?
Huh?
The younger one?
No, yes, you said the older one?
The younger one.
Younger one, yeah, she's 14.
Oh, dang.
Yeah, but I mean, like, it's up to you, dude. Just let me know.
All right, what's the donation?
Well, it depends on what you want to do.
Just want the heads and some sex, and that's it.
All right, with Delaney, the younger one?
Yeah.
All right, just head and sex. You just want to call it $100?
Okay.
We can do that. She's about to hop in the shower real quick, but yeah. Where are you at right now?
Heading to Walmart right now.
Walmart and Crestview?
Fort Walton Beach.
Fort Walton, gotcha. Yeah, well, we're in Crestview, so just hit me up when you're ready, man.
Oh, dang. All right, bro. I will give you a call if I'm ready.
Say again?
Yeah, I will let you know.
Yeah, just shoot me a call, give me a text, whatever.
All right. Thank you.
All right, bye. Yep, bye.
Let's keep in mind what Special Agent Horn and also Investigator Evans told us about the type of website that Skip the Games is. They both told you that it's a website known for prostitution and human trafficking. You also heard from the defense's cross-examination of those witnesses that Skip the Games is an adult site and is not for long-term relationships. It's for just having sex with people, paying to have sex. The reason why I told you to pay attention to the name of the profile that said Delaney is because when he then called, he was asked, are you calling for Delaney? Yes. Okay. The officer didn't just tell him, okay, this is what it is, it's going to be $100. He didn't say that. He actually gave him a choice. He told them, I have 2 females available, Jan 39, Delaney 14. And he's asking, his concern was, well, which one is better? Think about it. What did the officer say? He didn't tell him which one was better to try to convince him to do anything that he wasn't going to do. He said, depends on what you want to do. And the response was, with no hesitation, head and sex, that's it. And then he chose the younger one.
Hello?
The officer, think about it, offering him a choice, gave him a way out. He could have said Jan 39. He didn't show disgust when he heard that a little girl, 14-year-old, was available. And he testified he was over 40. He's over 40 years old. He didn't hang up when he heard that. He didn't say that that's not what I'm looking for. We never heard that. Didn't express any surprise, disgust, or hesitation at the mention of the 14-year-old. And I ask you to review that recording, because what's important also is not just the words said, but how he said it. That okay, makes a difference. And he insisted on the younger one. He gives him an out. Do you want the 39 or the 14? He didn't take it. He said the young one, and he made sure that he understood, the agent understood that he wanted the young one. Those are not the words of a man who was confused, nervous, didn't know what he was doing, innocent. These are the words of a man who understood exactly what he was agreeing to, and he agreed anyway. Pay attention also again to the words used. When he made the deal, how did he ask for the price? He didn't say, how much is it? That's what I guess people would ask in the same situation when they want to know the price of something. He used a specific term, donation, very fluently. Didn't hesitate a bit to say, what's a donation? That's how he said it. And you can hear it for yourself. You'll have the recording with you for further examination. The agent is not telling him how much it is and what it is. He asked him, what's the donation? And he said, $100 for oral sex and vaginal sex with the 14-year-old. And again, he said, okay. He was happy with the deal. Then, after he makes the deal, he reaches out to Special Agent Orr via text message asking for the address. He wanted to know where to go to see the 14-year-old. And he was told to go at the Fairfield Inn in Crestview, for Walton Beach to Crestview at midnight. You all know, if being from this area, how long it takes from here, for Walton Beach to Crestview. Everything was confirmed by the agent. Everything that matters about why Mr. Sterling got in his car is exactly that 1 minute 59 seconds phone call. It tells you exactly what he believed he was driving to. It tells you exactly what he intended to do once he got there with the 14-year-old. And it certainly tells you that he was not confused, he wasn't misled, or didn't stumble into anything. He went to Crestview directly. He texted the agent, or the person he believed was the custodian of the child, that he was there. And he made sure that he knew that he was there when he sent the photo. Nobody forced him to do that. Think about how many steps you have to take before you reach Crestview from here. First of all, you have to decide to go. Second, you have to get in your car. You have to drive. You have every single mile on that road to change your mind, turn around, and go back where you came from. Every red light that he found, he could have turned around. Every exit. He never stopped. He was determined to reach the destination, and he even had the $100 in his pocket to pay for the services that he had bargained for. And then, once he got there, what happened? You heard Investigator Staley testifying about his interview with the defendant. He lied to him. He said, oh, he was just in Crestview to clear his mind. He was stressed from work, he was just driving, and driving is not illegal. Yeah, but that wasn't simply driving. He had a destination to go to, wasn't aimlessly going around to clear his mind. And again, we know that because of the text messages, the numerous searches that he did on the website, Skip the Games, that you will be able to review. He went in a parking lot of a specific hotel at the specific time agreed upon by the two, on a specific phone call, in which he arranged to pay for sex with a child. There is no innocent version of that coincidence. When the recording was played for him, you remember from the interview, he denied it was him. He didn't remember the phone number. He was asked and he only gave the area code. You heard exactly what was in his mind when he was talking on that phone call with Special Agent Horn. Every lie that Mr. Sterling told after his arrest pointed in the same direction. What he was trying to do was distance himself from that phone. He wanted to get away from that call, denying that it was him, and wanted to be away from that hotel, saying that he was just driving there aimlessly. But the phone every single time pointed right back. The judge has read the instructions, and the state has to prove, beyond a reasonable doubt, that ANCEL KIMANI Sterling used a device capable of electronic data storage or transmission to solicit, lure, entice, or attempt to solicit, lure, entice a person believed by the defendant to be a parent, legal guardian, or custodian of a child to consent for the person believed by the defendant to be a child to participate in unlawful sexual conduct in violation of Chapter 794, 800, or 827. Second element is the traveling part. He then traveled within the state for the purpose of engaging in any legal act. So, how does the evidence fit every element that supports proof beyond a reasonable doubt? Element 1 requires a device, two-way electronic device, and the solicitation, I've called the facilitator, the custodian, the person who has control over a person and is offering the person for whatever services in the particular case. So we have the phone, you know he was on the phone, you know that he sent text messages, he took the photo, we know all of that. He called the number. Special Agent Hoare did not randomly call this defendant and initiated any kind of conversation. He just posted the profile, he put a bait, and he took it. He called, so he called to have sex with a 14-year-old girl. He told the law enforcement officer that he wanted the 14. That's a solicitation. What's the unlawful sexual conduct? Oral and vaginal sex with a child. That's the unlawful conduct that he was soliciting for. He said, I want to have head and sex with the 14-year-old, the younger one. Element 2 is the travel within the state. Even the defendant himself confirmed that he did travel from Fort Walton Beach to Crestview to have sex with the person he believed was a minor, 14-year-old. You've also heard from the instructions that if you don't find the defendant guilty of this main charge, you may consider whether he's guilty of the lesser included. So the lesser included is soliciting a parent, legal guardian, or custodian of a child for unlawful sexual conduct using computer services of devices. I'm sure that you all know something. Basically, this lesser included offense corresponds to element 1 of the primary offense. What's missing from the lesser included offense is the traveling from within the state, right? Now, we do know that he traveled. That's 100%. You heard it from the evidence where he was arrested by law enforcement. You heard it from the defendant that he traveled there. So there is no doubt about that. The state believes that the main charge has been proven beyond a reasonable doubt, which is the second charge that we're here for is the unlawful use of a two-way communication device. There are two elements for that charge. The defendant used a two-way communication device, and he did so for the purpose of facilitating or furthering the commission of a felony. The court has instructed you, you don't have to decide that the felony in this case is traveling to meet a minor facilitated by parent, legal guardian, or custodian. That's a felony, and the judge has instructed you in that regard. So, how do we meet element 1 is the phone, right? And then, why did he use the phone? Why did he contact? To have sex with the minor. So that's a felony. He traveled to have sex with a minor. He used the phone to navigate. Investigator Evans testified that in reviewing the defendant's phone, he noticed that he used the GPS to get the location of the Fairfield Inn. And he also took a photo to reassure the agent that he had arrived at the agreed upon destination. So in the second count, use of a two-way communication device has been proven beyond a reasonable doubt. And the instructions also told you what a reasonable doubt is and what it is not. That's the standard. And the state embraces that standard. The state is not asking you to convict Mr. Sterling on a hunch, on suspicion, or on the word of any particular witness. The state is asking you to convict him based on the evidence that you've heard, based on that recording, and what you make of it. The state is asking you to review and consider the physical evidence in finding him guilty, the cash that he had on his person, the phone that he had with him, what he said and what he texted. What else? The lies that he told law enforcement when he was first arrested. He said that he was married, he didn't know where the wife was located, somewhere in Ohio. So he was here alone. Reasonable doubt is not an imaginary doubt. It's not doubt conjured from thin air, from sympathy, or from a reluctance to accept what the evidence plainly shows. It is a doubt based on reason and mainly common sense. You heard his own voice. You have his own phone, his own photo, his own cash. There is no reasonable doubt here. There's only evidence. He is the one who made those choices. Nobody else did that for him. He chose to go on their website repeatedly. He chose to make the call. Chose the child. Chose the 14-year-old. He chose to keep going when he could have walked away. Think about it. How many opportunities did he have to walk away from committing the crime, and we would not be here today? He chose to get in his car. He chose to drive. He chose to pull into the parking lot. He chose to have the cash on him, and then when he was caught, he chose to lie. Every single of those choices has been proven beyond a reasonable doubt with the evidence that you'll be able to review and that you heard during trial. At the end, when you go deliberate, I will ask you to find the defendant guilty of traveling to meet a minor, facilitated by parent, legal guardian, or custodian, and guilty of unlawful use of a two-way communication device. Thank you.
Yes, sir.
Is it showing active going? Is it showing active at the podium?
Good to see the young people occasionally struggle too.
There we go. Okay. Sorry about that. May it please the court, Your Honor, state, audience, members of the jury. I'm introduced myself before. I'm Sean Rapella. My partner is David Rare. We represent Mr. Sterling. He's our client. The way this is going to work is the prosecutor already did their initial closing argument. We're going to do ours in its entirety as one time, and then the prosecutor is going to be able to come back and then rebut the arguments that I'm making now. That's how the system works, and we accept that. So my closing is going to be a little bit longer than her initial, but she has another opportunity to talk to you. Okay? So that's how that works. I want to, first of all, compliment you all on your ability to stay focused and pay attention. I know many of you were taking notes. I know if you weren't taking notes, I know you're paying attention, and we really appreciate that. Now, as I go through the closing argument from our perspective, I'll say this is kind of a technical case. I'm going to have to be very thorough in what I'm presenting to you today. And you may want to take notes, and I encourage you to do that. Or I just encourage you to pay attention. There's some details that are important here, and so we want to point those out to you. And so when you go back to deliberate with your fellow jurors, you may want to be able to recall some of these things that may end up being what you determine to be reasonable doubt in this case. And we think there's a multitude of factors that would lend itself to be considered reasonable doubt. And I'm going to point those out to you, but try to either note them or recall them so that when you do discuss it, you can discuss it intelligently. Now, like I told you before, this is a technical case, all right? And we're not really trying, I have to take issue with the state said, we're not trying to over-explain away anything that happened. We're accepting what happened, and we're telling you that based on everything you've heard, our client is just not guilty of what he's charged with, okay? And I'm going to explain to you why. Like I said, this is a technical case. The chronology and the order of events really matter, okay? The police tactics that were used, that were employed in this case, matter. And it related to how the situation unfolded, okay? Now, if the state's arguing that the solicitation was him offering a donation, we would argue that's like the cart before the horse, okay? The police, namely Agent Horn, did the enticing. He did the luring, he did the solicitation, and that began at the very inception of the profile that he created for this Miss Delaney. That's when it started. The solicitation, which was a profile set up for a casual relationship on an adult seeking an adult. There's no question, and it's not disputed, any of that, okay? But what happens when an adult seeking an adult takes the initial bait, which is actually a front for a sting operation, a sting operation that's meant to target child predators? Well, that's what we have here. We would submit it's wrong because it would seem wrong because it is wrong. But that's where the solicitation began. Make no mistake. And that is our argument. You ask yourself, when did the status quo change from this being an adult seeking adult? Well, the phone call it's when it started, when the status quo changed, okay? When the enticement changed, okay? That was a change in the entirety of the circumstances. The judge told you at the beginning, he said you have to follow the full and complete jury instructions in this case, okay? So, and that means every element's going to have to be looked at very closely. We're going to go through that with you. But I want to remind you that Mr. Sterling's only on trial for what he's charged with, okay? That's your only concern. If he committed adultery, or if he was intending to commit adultery, that is not a charge that you can concern yourself with. And even if you don't like him, if you don't like myself or Mr. Rare, you don't like our tactics or our way we present ourselves or how I dress, too bad. You have to follow the law, and the judge instructed you that that's your requirement, that's your duty, obligation. Okay? We would propose that the state's case is basically that he's guilty because he traveled, and he's guilty because he responded to the call made by the officer. Okay, well, I think there's more to it than that, okay? The jury instructions tell you there's more to it than that, okay? Because we'd submit the police duped him into traveling to meet either a woman or in her 20s, who was the person on the profile, Miss Delaney, 24-year-old actually, or possibly someone posing as a younger version of themselves, and that's a possibility as well. That was a possibility that was discussed by Mr. Sterling. Do the ends justify the means? We would suggest that they do not, and that's why you're going to have the entrapment instruction that we'll talk about later. The elements of this charge require more than just traveling, okay? And we'll go through those as well. We have to ask ourselves, what was he actually seeking, and what did he actually solicit by making the initial call, okay? Now, I want to show you something here. This is Defense Exhibit B1, B2, and B3. You'll have a chance to look at this in more detail. All right? Now, I'll point out a few things to you. There are things in this profile that be indicative of an adult. Okay? Pictures were of an adult. She's 24. She's an analyst. Okay? Officer Horn said that he changed the face, but then blacked it out. There's also things on here that would suggest that she's experienced. I see men, women, and couples, and she she's 5'4" to 5'7", which is not short. Her breasts are small and petite, and she's shaved. Well, that's attractive. And she doesn't have any piercings or tattoos. And she's interested in things like being outdoors and fishing. Very attractive. And nothing in this profile suggests she's anything else than an adult. There's nothing in here, even her age, 99 years old, which is, well, that doesn't suggest that she's a child, certainly. She just doesn't want to disclose. Maybe. Okay. We happen to know that she's actually a real person in her 20s. Mr. Sterling testified that he believed that she was a person in her 20s, and he was right. So we ask ourselves, who was enticing? Who was luring? Who set up the profile? It was the police. It wasn't Mr. Sterling. He wasn't doing it. Who were the solicitors? The police. Okay? When the state attorney put up on her screen, she wrote, where the case begins, the phone call. I know you saw that, all right? You have to ask yourselves, the phone call from whom? From whom? The phone call that Mr. Sterling placed in response to the ad that was unanswered, or the return call from the officer? I think the state would want you to think, or want you to believe, that the case started and initiated then, when he was called back. But it wasn't. It was before. It was when the inception of the profile began. You've got to go back in time. That was when the luring, that's when the enticing started. Yeah. He responded to a profile of an adult woman. The call was from the police to our client. Make no mistake. This is when the enticement aspect really began for legal purposes. Police initiated and solicited Mr. Sterling by suggesting an escort prostitution type scenario, and for the first time that was brought up, it was all from the police. Okay? Mr. Sterling also did not solicit the girl's legal guardian, parent, or custodian. That person on the phone never identified himself as such. We don't know who he is, actually. Mr. Sterling didn't know when he testified. He didn't know who it was. And Officer Horn testified. He never disclosed. He never identified himself. If you need to listen to the video or the audio, please do so. We encourage you to do so because we're confident that's what it was. Mr. Sterling didn't ask when he got on the phone, I'm looking for a child. He didn't ask. The woman in the photo, was this woman 39 years old, Jen? A bit extra? No, she was thin, she was petite. Was she 14? No, she wasn't. She was actually in her 20s. This is not an opinion, ladies and gentlemen. This is an uncontested fact. Now, in addition to all this stuff, we've got a legal disclaimer on the site, on every page of the site, as Mr. Sterling indicated. A legal disclaimer is reasonable doubt in and of itself. Okay? I am a professional service provider. Any fees or compensation paid to me are for my time and companionship only. Any actions that take place within our contacted time frame are a matter of mutual choice between consenting adults. I might want to point out here, it actually says I. It's in the first person, I. So it's directly relating to the profile, I. That's what's on the site, I. It doesn't say our profiles are for our professional service providers based on the site. This is an I. Was that on purpose? I don't know, but that's what it says, and we can't avoid that, all right? Any scenarios, fantasy or otherwise, contained in this post are purely that. They do not constitute any form of contractual obligation. I do not engage in unlawful acts. I reserve the right not to enter into any arrangement with those whom I reasonably believe to be under the influence of drugs, alcohol, or for any other reason at my sole discretion. Okay? So the I part talks about I do not engage in unlawful acts. It also mentions any scenarios, fantasy or otherwise. We can't ignore it. It's there. It's reasonable doubt, ladies and gentlemen. Okay. When the prosecutor tested, or she didn't testify, she argued just a little while ago. She said he took the bait. You remember that when she said he took the bait? And implying that the bait was for a 14-year-old, but that wasn't the bait. By calling the police, the bait was the adult profile. I want to go through the state witnesses one by one, because I want to be thorough here. Okay? First, we have Agent Horn. All right, he was the role of the chatter. Now, I would suggest and argue that his confidence in what he was doing probably exceeded his experience level. He'd only been doing it a little while. Now, he said he set up the profile as a purported minor. Did you catch that? He said, I set it up as a purported minor. That's just false. That's not true at all. He did not set up the account as a purported minor. There's nothing in the profile that would suggest that. So that's not true. He admitted on his testimony that the youngest age you could choose is 19. Okay? And he also admitted to tactics that were of a, what do you call it, a more proactive approach. Interesting. He admitted that the photos were of a 24-year-old analyst, a real person, and her face was age regressed, but also scribbled out later with the black marker. He said the initial photos of the profile that he initially created when he constructed this account were actually flagged by the site as being too young. Okay, so what did he do? He went and changed it to make her look older. Okay, all right, to comply with the rules so he could get his post up there. And guess what? He was successful. The profile had to appear more adult, so it was. Okay, now this makes zero sense if he was actually targeting child predators, right? It makes no sense at all why he would do it that way. Okay? Like I said before, the profile is consistent with a sexually experienced woman, men, women, couples. He admitted to that. He set it up. He purposely put all that in the profile, okay, to lure and entice. There's no question. The stuff in there, those pictures, their poses, the stuff that men, women, couples, and the things that she's talks about her grooming habits, that's all meant to entice a man seeking, or a couple, or a woman seeking an adventure with the person in the profile. That's enticement. That's luring. She's fit. She's attractive. She's thin. Those are attractive qualities. Now, he also testified this, and if you caught this is important. Back in August of 2024, that Mr. Sterling had clicked on the profile because they had some kind of record of this, and then it didn't go anywhere because they weren't available or something, right? So why does this matter? I'm going to ask you that. It might be a simple thing, but maybe it's more to it. Well, I would argue that it goes towards the legitimacy of the profile itself, okay? He clicked on it in August. It's November. Almost 4 months go by. The profile is still up, okay? It's not been taken down. Does that suggest to you that the profile is maybe more legitimate if it's been up there longer? I would suggest, and I would argue that it does, especially if Mr. Sterling believed that he remembered that he had clicked on it before, but we didn't get there. We didn't ask him that, but if he did, that does matter. Okay. Agent Horn also corroborated the disclaimer language is accurate and present on the profile and site. He said, I know it's there, maybe ignored it. All of this that I've just talked about is reasonable doubt. All of it. Okay? Let's talk about Officer Staley. Okay, by the way, this is all after the arrest. Okay, Mr. Sterling never admitted to actually wanting to have follow through with the sex with a 14-year-old. He never acknowledged that he intentionally wanted to do that. Okay, he admitted to doing other things and to what he had actually done, but he never acknowledged that he wanted to actually follow through with this if it was a 14-year-old girl. Okay? Now, the whole purpose of this interrogation stage is to get him to admit that that's what he really wanted to do, to confirm for the police so they could confirm they really had a child predator on their hands. They didn't get that from that interview. Okay? Then we got Casey Campbell, who testified. He said he did a scan of the full phone, full scan. They're looking for everything on that phone. They're wanting to download pictures and internet searches and everything. Is there anything that they testified to that would suggest to you that there was any evidence on that phone, besides what we were presented today, that would suggest that he had a propensity for child predation or that he was seeking children? Did he have pictures of children on his phone that would suggest that? No. If there was, you would have seen it. Okay? There's no evidence of that. All right? The only photo of note was the one outside the hotel. Nothing else. Okay? No evidence at all on the phone that would suggest he was looking for a minor child. They were looking for that. They didn't find anything, or you would have known it. Okay? Then the state rested, and then we heard from Mr. Sterling. Let's talk about him. He did explain his perspective. And let me tell you, it didn't look like it was easy for him to testify. It was hard. But there's a reason we're here and we're challenging these charges. And hopefully you know by now and you understand why. He was honest. He admitted to what he did, but he also gave insight to his state of mind and his intention. When he said, dang, remember that? The dang. That was a surprise. It wasn't pleasure. It was a surprise. Okay? Listen to it again if you don't agree with me. He did not solicit the custodian, or whatever that person might have been, but never identified. And he did not have knowledge of the person he was talking to, who that person was. Now, you might not like him. You might think Mr. Sterling is a bad guy or he's not a good husband or a bad father, whatever he might be. But he's not on trial for that. He's not on trial for being a bad husband or being interested in having extramarital sex. He's on trial for what he's charged with, and that's your only determination today. Okay? He's not on trial for seeking an adult prostitute or an escort service. He's not on trial for that. Now, his testimony does not contradict really any of the other evidence in the case, but it does help us understand the full situation. In the video, he said he did not, in actuality, he never met anyone underage, still believing the woman in the picture was an adult, even after the arrest. There's two statements he made in that video with Officer Staley. He said, girl wasn't no 14-year-old. okay? I'm not trying to, I can't do a Jamaican accent, but he said, girl want no 14-year-old. I wouldn't do that. He said that. He also said, was not soliciting no minors. He said that as well. So he stuck to that, even though they were interrogating him. Obviously, he was scared, he was nervous, and that reaction, I think, is normal. He was evasive, but the important things, he was honest with it. He admitted fault, he admitted his wife was out of town, he was seeking an adult. He was adamant he wasn't seeking a child. He relied on the idea that the site was for adults only. He believed that Miss Delaney was still an adult in her 20s, despite being told she could have been younger. He wanted to verify. He believed that he hadn't had enough self-control to believe the fact that if she wasn't over 18, he would have left. Okay? He never laid eyes on the real person. He only had the photo and the picture in his mind of the adult profile and the girl in that photo that he was relying upon. He knew about the legal disclaimer on every page of the site, and he relied on that. Everything that you saw in this trial today would be consistent with the fact that he lacked the intent to actually have sex with a minor child. I think we can honestly say that. Now, like I said before, the judge has instructed you that you must follow the full and complete jury instructions and that each element must be proven beyond a reasonable doubt. Elements lacking evidence in this case? Well, I can tell you there's a couple on count one of the traveling charge, okay? And that is the part where it says that the defendant believed the person was a parent, legal guardian, or custodian. There's no evidence that that person was ever identified as such, and that is enough to say that that element has not been satisfied in and of itself, okay? The other part of element one that's not been satisfied is that the defendant lured, enticed, solicited. No, that's not what happened. The law enforcement officers did that. And we can't just change the instructions to reread it, to change it to say, let's see, we can say that he was enticed by law enforcement to believe. No, that's not what it says. It says that he did it, okay? So we have to follow the instructions we have. We can't just ad-lib it and try to come up with something else. It is what it is. That's what we got to follow, okay? Who was the enticer and who was the enticee? Who was the enticer and who was the enticed? Police were the enticer. Mr. Sterling was the enticee. He was the one being enticed. So the state cannot prove count one. Make no mistake. They can't prove count one. They can't prove it based on the fact they can't prove element one for a couple of different reasons, like I said. Okay? The traveling part, you don't get there in terms of if you can't get number one, you can't get number two. Okay? They have to be, you must prove the following two elements beyond reasonable doubt, not just one. Okay? And now there's another part of that instruction where it says, and I want to make sure you understand this, the mere fact that an undercover officer of law enforcement was involved in the detection and investigation of this offense shall not constitute a defense of prosecution. Okay. So it doesn't negate all defenses for this case because there was law enforcement involved. All it says is the mere fact, in and of itself, that an undercover officer was involved doesn't negate the fact that they can pose as a child if they wanted to. So they can pose as a child, and that's allowed to detect crime, right? But what we're arguing they can't do is they cannot do that in a way that would be misleading, and that's what they did. Okay? So that in and of itself is not a defense, but it doesn't negate anything that has to do with element one, like I said. None of that. I just don't want you to be confused that that's like some kind of disclaimer on, law officers can do whatever they want. They can't. They have to follow the law. Okay? It doesn't give them a carte blanche to do whatever they like. That's the point. Okay? And like the state said, count one and the lesser included of count one are related. So if you find him not guilty on count one, you have to find on the lesser included, he's not guilty as well. And vice versa. Okay. That's the second. That's the lesser included offense. See, it has the same exact wording in it as the first charge. Talking about soliciting or enticing, talking about the person believed to be the defendant believed to be the parent, legal guardian, custodian. Those are the same issues, same problems they have in the first charge of the traveling. Okay. There is a count 2, and I want to talk about that. Unlawful use of a two-way device. Okay, so here's that one. All right, so let's look at that. All right, two-way device is pretty broad. State's alleging that's a phone. Can't really dispute that as a phone. We're not going to disagree that the phone is the instrumentality that they're saying. Falls into that. We have an issue with number 2, though. He did so for the purpose of facilitating or furthering commission of a felony. Well, let's break that down. Okay. If the state can't prove count 1 or the lesser, then count 2 requires a verdict of not guilty. The only available felony for you to consider is count 1. There are no potential felonies or other things that you could consider in that regard. You cannot speculate. Okay, this is a simple matter. There is no other evidence available, no other charges for you to consider. That's the charge that they are married to in this particular count. All right. So if he did not commit a felony because they can't prove it beyond reasonable doubt, then he's not guilty of count 2 because it talks about commission of the felony. Okay? He didn't commit a felony. The state has to prove that he committed the felony in order for that to be valid as a count, as a charge. Okay? Let's go on. Okay, let's see. All right. Reasonable doubts abound. We would suggest that they do. Details matter. Like I said before, I asked you to review your notes. Review your thoughts. Talk about it when you get a chance to deliberate. Review the evidence if you need to. I encourage you to read. Everyone should read this. Read the profile. Read the legal disclaimer. Notice that it's in the first person. Pay attention to this. Review all of the video, all the evidence. I'm not suggesting you should withhold any of that. You should look at it and peruse it as long as you like. We want to make sure you get this right. Okay? We're depending on you to make sure you do it right. Okay? Please don't assume anything, all right? So it's like, you hear someone say, well, I thought that he said that. Well, let's not assume he said that. Let's make sure and then discuss it, okay? Don't skip over certain things. Make sure you do it and you do it in a respectful way. I know you will, okay? Now, even the prosecutor in the case said a few things in her opening that I want to correct because it's not what happened in the evidence as it came out, okay? At the beginning of the state's opening, she said the defendant called the number and the police answered. No, that's not what happened. The defendant called the number, the police didn't answer. Then the police called him back. That's an important part of this thing. And we can't just assume that he called them because that's not what happened, okay? That wasn't one phone call. It's critical, all right? She also admitted in the initial opening statement, and this is not evidence, of course, but it's indicative of what they're arguing. She admitted the man on the call was a police officer posing as a pimp. Okay? Not as a custodian, not as a parent, not as a guardian, and there's no evidence that came out during the trial that would suggest that we have that as evidence. Okay? You can't make a nothing burger out of nothing. Okay? Or you can't have nothing but something like that. Okay? Now, she also talks about the fact that he chose, he made the choice, he made the choice. He could have chosen Gen 39. Could have chosen Gen 39, okay? We would argue that the officer could have offered the 24-year-old, okay, as opposed to 39-year-old. He could have offered 24, he could have offered 20, he could have offered 18, but he didn't. He made the choice 39 or 14. 39 and a little extra, or 14? And the 14-year-old was not in the profile, like I said. 39-year-old was definitely not in the profile as well. Okay, so after all that, You might be thinking to yourself, I think there's reasonable doubt here, and I would agree with you if you thought that, right? There's reasonable doubt to find our client not guilty. But there's one more issue to consider, okay? So if you believe, after all that he's still guilty, okay, well, there's another defense that you have to consider before you can get to the end, no matter what. Now, I'm not conceding at all that we have a case where the state's proven their elements beyond reasonable doubt. I'm arguing strongly that they didn't get there, okay? And you don't even have to get to entrapment. But entrapment is something that you have to consider if you think that they did prove it. If you want to review this, fine, you can. I'm going to go through it because entrapment's kind of a nebulous thing. It's you've probably seen it on TV. We didn't talk about it up to this point, so let's go through it. If you have your jury instructions, I just want to go through it. Let's see here. Let me see. So, first one is, and we have to get all five, all right? The first one is, he was, for the purpose of obtaining evidence in the commission of the crime, induced or encouraged to engage in the conduct constituting the crime, which is all counts and lessers, by the way. The crimes charged and lesser proven offenses. That's all of it, okay? Now, he was induced or encouraged. We would suggest that he was induced because the profile said it, all right? Which set him up in the initial part of it. Number two, he engaged in such conduct as a direct result of that inducement. Well, of course, if the profile didn't exist, then he would have never called it. That's an easy one, all right? The person who induced or encouraged him was a law enforcement officer or a person engaged in cooperating with the activities of a law enforcement officer. Yeah, it was a law enforcement officer. It was Officer Horn. We know that, so we can satisfy that one as well. And number four, the person who induced or encouraged him, Officer Horn, employed methods of persuasion or inducement, and we're going to define what we think is an inducement in this case, which created a substantial risk that crime would be committed by a person other than one who is ready to commit it. Okay? And then number five, and we believe that that is true. Number four, yes. Okay, number five is that Mr. Sterling was not a person ready to commit the crime. Okay? And the reason we can argue that he was not ready to commit the crime is because there's no evidence of predisposition to commit the crime. Okay? There's no evidence of that. There was no evidence that he would have committed the crime otherwise if in another format or something. So there was no evidence of that provided to you whatsoever. Okay? If there's no evidence, you can't just assume. That's the point. Now, entrapment is not a defense of the crime if the defendant had a predisposition. Like I said, there's no evidence of predisposition, so we're good there. And then had the predisposition if the law enforcement officer or person acting officer persuaded, induced, or lured the defendant, which he did, had a readiness to commit the willing to commit the crime if the opportunity presented itself. Okay, so this whole part here is that he doesn't get the entrapment. He doesn't win on entrapment if the state can prove the predisposition, which we have no evidence of. So that one, we're good on that as well. Okay, and then it says, it's also not merely because a law enforcement officer in good faith attempt to detect crime, okay, did these other things. So when we look at merely, in and of itself, again, in a good faith attempt to detect crime, well, we'd have to argue, was it good faith attempt, or was this bad faith? Number one, we submit that it's bad faith attempt to detect crime. And detect crime, that's assuming that the crime is already occurring and that he's in the process of trying to uncover it, okay? Which we don't have here as well, okay? So, as to A, it says, provided the defendant opportunity, means, facilities commit the offense, which the defendant intended to commit would have committed otherwise. There's no evidence of that, okay? There's no evidence of his pre-intent to commit the crime. There's none of that. So, A does not apply, okay? Number B, use tricks, decoys, or subterfuge to expose or uncover, I would suggest, the defendant's criminal acts. That's what exposing means, to uncover. Well, was he committing crimes before? No, there's no evidence of that. So that one doesn't apply either, okay? Was the decoy a child? No, it was an adult. Okay? Was he already engaged in some kind of criminal activity, like a drug dealer or something? Was he out there doing drugs and trafficking children? No, there's no evidence of that whatsoever. Okay? And you can't assume there was, or that he had an experience in the past with a child or something. You can't assume that because there's absolutely zero evidence of that. Okay? So it's kind of like in the past tense. You know, these are things that we're exposing them, which would be uncovering them. Okay? You can only expose something that's already in existence. That's my argument. Okay? Now, on the weight part of it, page 2, or on the bottom, it says, the issue of entrapment talks about greater weight of evidence. Okay, so let me paraphrase that a little bit. All right, so when it comes to entrapment, it's a preponderance of the evidence, which means that a little bit more than half, right? 51% if you want to use that. That's the standard of proof there, okay? And if they find that, then the state has to, beyond a reasonable doubt, show the predisposition part of it, which we would say that they can't prove because there's no evidence of it, okay? So then it goes down below there, it says inducement, and they're defining inducement, because this inducement's a word that's used throughout this instruction, right? And there's some of these things on here that I mentioned that we don't fit the category of it all, right? There's no harassment, there's no promises of reward, please read any of that. But the one that we're concerned about is the fraudulent representation part, because that one fits us to a T. We have a fraudulent representation of the adult profile, Ms. Delaney, that was adult, all of it, the disclaimer, all of it going into it, fraudulent, okay? The fraudulent profile was the inducement that carries through all of these instructions, okay? And if you find that he was entrapped, you have to find him not guilty of all the counts. You can't cherry pick and say, well, maybe you can find him guilty count 2, or no, it's all of it. It applies for the totality of the chronology, okay? So it is an affirmative defense, we call this, okay? So you may have been thinking about entrapment from the moment we started our opening statements, when Mr. Rare was telling you about what the police were doing. Well, now you have a framework to find our client not guilty based on entrapment by following these guidelines. And I hope I've been able to go through these with you and you understand them as well as you can. I encourage you to discuss those and work through them as a team and figure out the right answers and understand them. We would submit that he does qualify for entrapment, even if you find that there's no reasonable doubt on the rest of it, like I said, but we're not conceding that. It would be improper for us to concede because I believe, and we believe in this case, okay? So, this is the prosecution's best case, okay? And we're not trying to be slick attorneys, trying to get a client off on a technicality. These situations come up in the law where a client is charged in a certain way, and the facts are a certain set of facts. And the law is what it is, and the facts are what they are, and the law is applied to the facts. And your job is to apply the facts to the law and follow the law. We know you'll do that. You have to be objective, okay? You cannot think with your emotions or feelings, thinking, well, he's a bad guy, or maybe in the future or something. Well, no. This is just from what you heard today, or yesterday and today, all right? It's only what the evidence has. That's all you can go off of. And you can't hold against him that he's an immigrant from Jamaica. You can't hold that against him at all. That would be improper. You have instruction on that. You can't feel bad for the prosecution. Ms. Leone or her team, she's done the best she can do with the facts she has. She's done an excellent job, by the way. And you can't feel sorry for her if you find the client not guilty. It is what it is, okay? And that's you doing your job as we're doing ours, okay? I think that the way that the police handled this case, the way they did the sting operation was just horrible, okay? And you might have been sitting there during this trial thinking, yeah, something's not right here. This does sound kind of shady. Well, It's because it was. It's like, I would say, it's like as if they didn't understand the charge they were trying to set up and who they were actually targeting. If you want to attract child predators, don't use adults as bait and then do a bait and switch. That's not good. So their actions, the police's actions in this case, definitely Agent Horn, directly negated the element of the crime, which is what I talked about. Their overzealousness, his sense of entitlement, all that affected that outcome. And it's on him, okay? It's on him. He enticed, he lured, he initiated the fake accounts. That's all on Officer Horn. Because of all this, the state did not reach their burden of proof to prove all the elements of these cases beyond the counts, beyond a reasonable doubt, okay? So justice would require a verdict of not guilty, okay? It does. It requires it. You have to follow the law. And I've given you everything that you have from this case that we remembered and that we took notes on. I'm bringing it for you. I hope that you do your job. I know you will. And I thank you for your time and service. And I know our client, Mr. Sterling, does as well. Thank you.
Ms. Leo.
Yes, Your Honor. First, I want to tell you that this is not a technical case. We're not dealing with numbers, with science, medicine, right? We're dealing with the behavior of human beings like everybody else. It's not difficult to understand what went on, right? Again, Mr. Lupella said many words. Just get to the point. Use your common sense. I'm sure at one point or another, we all have been facing situations where we had to make choices. It doesn't mean that we all make the wrong choice just because we're offered an opportunity. That wouldn't be a law-abiding citizen doing that. One thing I want to point out is it's in your instructions. It's called weighing the evidence. One of the things that you want to look at, how to analyze the witness's testimony. And it tells you exactly how to do that. I'm going to focus on, was the witness honest and straightforward in answering the attorney's questions? There was no doubt that all the law enforcement officers were straightforward. They answered the question that they were asked. A person who was not straightforward was the defendant on the stand. He tried to first say, I didn't think the woman was, I thought the girl in the photo was about mid-20s. Think about what he said and the tone of voice, because I totally disagree. The tone of the exclamations of the defendant were of a pleasant surprise. You can determine that. Other one is, does the witness have some interest in how the case should be decided? Now, what I want to point out that has to do also with number 6, did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? We obviously have that, and he admitted it when I cross-examined Mr. Sterling. Remember what he told law enforcement? At no time, think about it. If he didn't think he had done anything wrong, why would he lie about it? There's no reason. An innocent person would have said, I didn't do that.
Objection.
He didn't give...
Objection.
Please approach. Ladies and gentlemen, I'd ask you to disregard the prosecutor's last comment. It is never a defendant's obligation to prove his innocence. You may resume.
Thank you. So at the time he was arrested, he didn't give any explanation reasonable as to why he was in Crestview around midnight, right? But again, we all know why after you reviewed all the evidence. The other thing that you want to consider when analyzing the testimony of any witness is whether or not that particular witness at some other time, if he had any interest in how the case should be decided. That's number 4, right? Now, obviously the defendant had, when he came here to testify, right? We know that this happened, the incident happened in 2024, November 15th, right? Almost 2 years ago. So he had 2 years to figure out what he was going to come here and tell you. Does he have any interest in the testimony? Of course he does, you know. But no other witnesses had anything at stake, you know, the law enforcement. You were told by Investigator Evans, he teaches classes, and they do those operations over and over. And this particular one, he said, there were many chatters. It wasn't just Special Agent Horn who was doing the operation. They follow a protocol. They follow some rules, and that's the purpose of the presence of Investigator Evans. He said that he would review the profiles before they would post them. He would review the conversations. He would determine all of that. And that happened. The defendant has something at stake out of this trial, of course, and it goes without saying. The other thing I wanted to point out, think about why a person would state one thing at one point and then something else at another point. As I said, at the time of the arrest, he hadn't had all the time to think what to make up. But he did have time to think between that time and yesterday on what he was going to tell you. Let's look very quickly at the entrapment. Again, please pay attention that it is not entrapment merely because a law enforcement officer, in a good faith attempt to detect crime, provided the defendant the opportunity, means, and facilities to commit the offense. Common sense. Isn't that exactly what Special Agent Horn has done? See, the way I see it, when you talk about the number one, he had to be, the person, the officer had to encourage the defendant to commit the crime, right? Encouraging, you have to think about the regular definition. We all use that word, right? It's like, for example, I offer an ice cream to my kid. I say, do you want strawberry or chocolate, right? And then he decides. Now, suppose I want to push him towards a specific flavor. I would encourage him, say, you know, you should really eat the chocolate one because it's of a better quality. You know, no, but I want the strawberry. No, I really think that you should get the chocolate. See the difference between just making the option available and actually leading a person towards deciding to do something. It didn't happen in this case, and you heard it with your own ears. You don't even have to base your deliberations on anything other than listening to the phone call. That says it. Then, he engaged in such conduct as the direct result of such inducement or encouragement. Again, there was no encouragement. If anything else, he was given a way out, and he did not take it. He insisted the 14-year-old. Now, the defense made a comment, oh, he didn't know he was a special agent, was a custodian. Again, common sense. If I'm saying that I have those two things available for you to have, you would automatically think that for saying that, I have to have control of those two things to make them available. So that element is met, clearly. The person who induced or encouraged him employed methods of persuasion or inducement, which created a substantial risk that the crime would be committed by a person other than one who was ready to commit it. Again, He didn't create any substantial risk by offering the choice of the 39 and the 14. As I said, he wasn't forced to drive somewhere. He wasn't threatened. He wasn't promised anything other than what he had agreed on. He didn't, for example, think about it. He wasn't told, oh, if you go with the 14, it's only $100, and you also get A, B, C. Nothing like that happened. Common sense. It's also fine. Now, number 5, and ANCEL Sterling was not a person who was ready to commit the crime. What else would you call ready? I don't understand. This is exactly showing that he was ready. Look at the text messages. He asked for the address. He is making sure that the agent doesn't leave with the girl, and he sends the photo of the hotel. He had cash in his pocket, equal to the amount that he had agreed upon. So how was he not ready to commit the crime? Now, he had gone on that website, even in the past. Again, he explained that his friend told him about this website. Now, we know from records and the fact that he admitted during cross-examination that he had been on that site before. Didn't just happen one time. And you will see, it's like many pages this thick, the list of the web searches that he did. You can all see it. It's all skip the games. Now, skip the games that, yes, it's for adults, right? But again, you heard the testimony that there are actually real children who are exploited on those sites. And that's the reason for those operations, to prevent that an actual child is hurt. Also keep in mind when it comes to entrapment that, and it's in the instruction, it's okay for law enforcement to use tricks, decoys, or subterfuge to expose the defendant's criminal acts. Again, if you want to say that because he pretended to be a pimp, special agent, or used the tricks, okay, that's fine, but that's legal. That would not qualify or offer the defendant the defense of entrapment. Let's see what exactly Agent Horn did. Yes, he created a profile. That's perfectly fine, according to the instructions on entrapment. He puts a profile of this girl. Now, he testified that the image that he placed on that profile was not just a photo of another agent who happened to be in her 20s. He said that he took the photo of that agent and he used age regression and AI. You know, today, everybody, if you got AI, you can take a photo of yourself and put the command to make you look like you're 7, 8, or whatever. That's what he did. Now, okay, we can have different opinions. Did she look, you can see it for yourself, did she look like a minor or she looked like a 24 years old? I think that she looked like a minor, but it doesn't matter. Why it doesn't matter? Because when he called, he was offered the choice. So it doesn't matter what he saw on the website, because straight out, at the very beginning of the call, did you call for Delaney? Yeah. I have 2 females available. He didn't just say, yes, Delaney's available, she's 14. No, he gave him the choice. And the choice that he made was only his. Another thing, what's the predisposition? He testified he's married. You heard in the interview that his wife was in Ohio, right? And then you see the jury instruction on, you will see it in the definitions after the crimes. Deviate sexual intercourse means sexual conduct between persons not married. That's what he wanted to do. That's why he went on the Skip the Games website. You heard that what that site is for. His friend had even instructed him about that website. He says that the friend told him to use the word donation, but again, he used it quite fluently. You'll hear it for yourself. He had to believe that that person was the custodian, because otherwise, think about it. If he didn't believe that the special agent would make the 14-year-old available, please, why would he drive all the way at midnight from Fort Walton Beach to Crestview? It wouldn't make any sense. Another thing, did you ever hear Mr. Sterling yesterday, or for that matter, when he was arrested, either time you can think about it. Did he ever tell you that he felt forced to make that choice? He never said that. But now he's claiming that he was forced to make a choice. His attorney is.
Objection.
Please approach.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
You never heard the defendant saying that he was induced to commit that act, right? Because he made that choice. Other thing again, anybody else, or I guess, when you're offered a choice, just use your common sense and make the right decision. Any kind of interest for having sex for the 14-year-old is not allowed by the law. Honesty, whether he was honest or not, is up to you to determine. It's up to you to decide that the state has met the burden beyond a reasonable doubt, and I ask you to find him guilty of both counts as charged. Thank you.
All right, counsel, if you'd approach.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right, ladies and gentlemen, the evidence has been received, the arguments of lawyers have been received, and now comes the one of the at least for me personally as a trial judge, one of the most uncomfortable times. Because the order in which your names were drawn, 2 of you were seated as alternate jurors. And you were chosen as alternate jurors because we picked you on Tuesday, we had the trial yesterday and today, and because things happen, sometimes jurors can't finish their service, and if we only pick 6 and somebody couldn't serve, then we'd have a mistrial and have to start over. But you've been here all week, but as an alternate, you can't go back into the jury room and deliberate. And since the rest of the jurors have been able to finish their service, I have to discharge you. Now, I hope you can understand also that we couldn't tell you who you were in the beginning, right? Because you might be over there taking a nap. And that's the reason it's uncomfortable for me, because I take seriously the obligations and the job of the juror, and I'm serious when I say if you weren't here, we couldn't do our job. But although I can't let you go in the jury room with the jury, you're welcome to remain in the courtroom if you wish to hear the verdict, or you may leave. You're also now relieved from your obligation not to discuss your work as a juror. However, it's up to you whether you wish to discuss the case with anyone or no one at all. This court's position is the right of privacy as a juror extends to you as an alternate juror, and you're not compelled to talk to anyone except by court order, but you're free to talk to someone if you so wish. On the behalf of the citizens of the state of Florida, the First Judicial Circuit, Okaloosa County, and all of us, I thank you for your service. Rachel, did you? I did. Okay, very good. Thank you for your service. And Ms. Sarami Long and Ms. Discharged. I have some final instructions for the folks that remain as the jury to deliberate this case. After I finish these instructions, you'll be taken to the jury room by the bailiff. The first thing that you should do is you should choose a foreperson who will preside over your deliberations. And the foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form all of you have agreed on when you've agreed on a verdict, and bring the verdict form back to the courtroom when you return. As I've told you before, during jury deliberations, jurors may not communicate, must communicate about the case only with one another and only when all of the jurors are present in the jury room. So what that means is, very practically, if one of you has to use the restroom, then deliberations should stop until that juror returns. And you must not communicate with any person outside of the jury about this case. And until you reach a verdict, you must not talk about this case in person, through telephone, writing, electronic communication, or email, or by any other means at all. You must not contact anyone to assist you during your communication, during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I've given, you must tell me by giving a note to the bailiff. I think we've already talked to you about your electronic devices. The rules do not permit you to have those in the jury room. The bailiff, I think, has already given you instructions on that they'll collect them when you retire to deliberate. And once again, I think they've provided you with a contact number, so in the event there is some emergency, your family or friends or whoever may be able to communicate, we will pass a message to you as promptly as possible should something come up. If you need to communicate with me about any issue, provide a note to the bailiff. The note will be passed to me. I caution you, however, if you voted, don't disclose in your note your actual vote or any split in your vote. That's not appropriate for the court to be aware. If you have a question, I'll talk with the lawyers and with the parties before I answer your question, so it may take some time. You should continue your deliberations and wait for my answer. I'll answer my questions if I can in writing. Most likely, though, we'll bring you back in the courtroom to answer your question in court. As you've heard repeatedly during the trial, the items that were received as evidence will be are exhibits, and they'll be provided to you with one exception. We have the cell phone that's not going to be taken back to the jury room with you. If you wish to look at it for whatever reason, you can give a note to the bailiff and we'll bring you back into the courtroom and you'll be able to take a look at that. There should be available in the jury room, if it's not there now, we've provided a electronic device on secured, which is clean and secure for you to watch the videos or listen to the recordings that have been admitted into evidence. If you need assistance with that, the bailiff can assist you, and if they're not able to do so, then we'll call IT who can give you a help to look at those things. I caution you, however, that you shouldn't do any deliberations at all while anyone is present in the jury room with you if you need assistance of a technical nature. So if you need that help and you need it repeatedly, then what I would say to you is ask them to cue it up and the button you need to push, and then make them step outside before you play it and before you do any deliberations. No one but the jurors may be present in the jury room while deliberations are going on. So just use caution while you're doing that. I know we sometimes fall into common patterns while we're doing that. Be careful about that so that there's no violation of the rules which govern this. As soon as you're retired to deliberate, the lawyers are going to come forward. They're going to look at all of the evidence, be sure it's complete, there's no extraneous matter there. So it just may take a few minutes before that evidence comes back to the jury room. You should go ahead and select your foreperson and begin your deliberations while you wait for that. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, well, 2.5 centuries now, right? We've lived by the Constitution and the law. No juror has the right to violate the rules that we all share. If you'll all rise for the jury, so the jury may retire to deliberate their verdict. Thank you. And counsel, if you go ahead and approach the court and review the evidence. The court finds the completion of the verdict form to be ordinary and regular. Please stand. Madam Clerk, will you publish the jury's verdict?
In State of Florida versus ANCEL, KIMANI, Sterling, clerk number 24 CF 2653. We, the jury, finds as follows. As to count 1 of the information, the defendant is guilty of traveling to meet a minor facilitated by parent, legal guardian, or custodian. As to count 2 of the information, the defendant is guilty of unlawful use of a two-way communications device, so say we all, dated July 10th, 2026.
Please be seated. The state of defense wishes the jury to be polled. You may be seated.
No, Your Honor, not the same.
Defense wishes the jury to be polled.
No, Your Honor.
All right. Ladies and gentlemen, I wish to thank you for your consideration of this case. Oops. Hold on just a second. The technology is... There we go. I wish to thank you for your time and consideration in this case. I also wish to thank you for some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have also recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. The lawyers and their representatives are not permitted to initiate any communication with you at all. Although you're at liberty to speak with anyone about your deliberations, you're also at liberty to refuse to speak with anyone at all. A request to discuss either your verdict or your deliberations may come from those who are simply curious, those who might seek to find fault with you, from the media or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Our legal system is based upon a principle that an independent, fair, and competent judiciary will interpret and apply the laws that govern us. The role of the judiciary is central to the American concepts of justice and the rule of law. Please recall the words of U.S. Supreme Court Chief Justice Stone shared with you before jury selection began. Jury service is one of the highest duties of citizenship, for by it the citizen participates in the administration of justice between individual and individual, and between the government and the individual, by which the Chief Justice meant that you, as jurors, become part of that independent, fair, and competent judicial system that is a foundational principle of the American form of government. For 2.5 centuries we lived by this system, and even with the problems and criticisms that this system has, the system of justice created by the founders in our Constitution remains the envy of all in the world who strive for freedom. I'd ask that you accept this copy of the Constitution as my gift to you for your service today. As you read the Constitution, I'd like you to keep in mind the words of James Madison: "A well-instructed people alone can be permanently a free people." On behalf of the citizens of the state of Florida, the First Judicial Circuit, Okaloosa County, and all of us, I thank you for your service. And I will now, for the last time, put you in the care of the bailiffs for your discharge. Thank you and good day. All rise for the jury.